Despite the numerous restrictions on dependent visas, the Home Office has published a new document titled Dependent Family Members in Work Routes, which explains how to legally live with your dependent in the UK, as from April 11th, 2024, without any restrictions on your path, especially if you are a skilled worker. This document was published on the 4th of April 2024. So, could this mean that the UK government is considering the options to remove all the bans on skilled workers' visas and let them stay with their dependent peacefully in the UK? Well, don't worry, because we've gotten answers to all these questions, as we have a deep research on this already, and we'll present the result to you in a bit. Before we begin, if you've not already, please subscribe to our channel and join our family. Okay, let's now begin with the ways you can stay with your dependents legally in the UK, as described by the UK Office in its latest release. Let's move to page 13, which tells us about dependent new requirements. It says, this section tells you about the requirements for dependents of lead applicants. Dependents must meet the requirements found in each dependent section of the lead applicant's route. See the appropriate immigration rules. For example, the dependents of a skilled worker must meet the requirements of paragraphs SW26.1 to SW46.2. They're simply explaining the process to join the lead applicant. The dependents need to meet the specific criteria outlined in the immigration rules for the lead applicant's visa category. The lead applicant, for those who don't know, is the person who got the work visa, e.g., the skilled worker visa you are dependent on. Let's proceed. Validity requirements: permission to enter or stay. Before considering suitability and eligibility, you must check the application is valid. In addition to the rules in each appendix, an application for permission to stay also needs to meet paragraphs 34 billion to 34G in Part 1 of the Immigration Rules. For guidance on assessing the validity requirements in Part 1 of the Immigration Rules, see applications for leave to remain, validation, variation and withdrawal. If you are not satisfied the application meets all the validity requirements, you should consider whether to request more information, reject the application or proceed to consider. Applications must have been made on the correct form. They're explaining here that before they even consider your reasons for staying, suitability and eligibility, they check if the application itself is valid. This means it meets the basic requirements to be processed. There are two sets of rules to follow: the general rules in Part 1 of the Immigration Rules, paragraphs 34 billion to 34G, which apply to all applications, and the specific rules for your particular visa category, which are found in the appendices. There's a separate guide available: applications for leave to remain, validation, variation and withdrawal, to help assess if an application meets these validity requirements. If the application doesn't meet all the requirements, the reviewer has options: ask for more information from you, reject the application altogether. If everything seems mostly in order, they can move on to consider your reasons for staying, suitability and eligibility. In short, this is a kind of initial screening to make sure your application is complete and follows the proper format before they look at the reasons behind your request to stay. Let's continue. Applications should meet all the following requirements. Any fee and immigration health charge must have been paid. The applicant must have provided any required biometrics. The applicant must have provided a passport or other travel document which satisfactorily establishes their identity and nationality. The lead applicant must have made a valid application for permission on, hold permission on or have settled while holding permission on the route which a dependent is applying on, unless applying under UK ancestry, and either. If the lead applicant has settled or become a British citizen, the dependent must already hold permission as their dependent. Any UK-born child must have been born before the lead applicant settled. For more information, the link to these documents will be left in the description below for you to check it out for yourself. Don't forget to subscribe to our channel for more on UK visas and immigration updates.